Okay, let's unpack this. You've likely heard about the intense legal and societal debates swirling around gender-affirming care for minors. Today, we're taking a deep dive into one of the most significant legal clashes on this topic, the case known as United States v. Scrutiny. This case went all the way to the Supreme Court, specifically challenging laws in Tennessee and Kentucky that ban this type of care for young people.
That's right. And to really get to the bottom of what's happening here, far beyond the headlines you might see, we're pulling directly from the source material. We've got the core legal documents, the detailed briefs filed by the Department of Justice arguing against these bans, and the briefs from the state of Tennessee arguing in favor.
Crucially, we've also got the transcript from the Supreme Court oral argument. This is where the justices grilled the lawyers live, really pushing them on the toughest points of their arguments. It's like getting to listen in on the ultimate legal strategy session.
Yeah, exactly. We've also incorporated insights from a recent documentary that explores the human impact of this case, looking at the experience of one of the plaintiff's lawyers and the families involved. And we'll pull in analysis from state court reports because these exact same issues are being debated and decided, in courtrooms across the country, sometimes with very different outcomes.
So, our mission here is to guide you through the absolute essentials. We're going to unpack the complex legal arguments, especially how courts figure out if a law discriminates based on sex under the Equal Protection Clause. We'll look at the dramatically different ways the medical evidence around these treatments was presented. We'll understand the broader context, what's happening in other states, the human stakes, and hopefully help you see the core fundamental questions the Supreme Court is grappling with here.
Specifically, the laws at issue are Tennessee's SB 1 and Kentucky's SB 150. Now, the key language here is that these laws broadly prohibit healthcare providers from giving things like puberty blockers, hormone therapy, and certain surgeries to minors if, and this is the important part, the purpose is to enable them to identify with a gender inconsistent with their sex assigned at birth, or to treat discomfort related to, well, discordance between their sex assigned at birth and their asserted identity.
Okay, so right away you can see the legal tightrope walk. At the heart of this entire debate is one central question. Do these laws actually discriminate based on sex? Because if they do, that triggers a higher level of judicial review under the Equal Protection Clause, something lawyers call heightened scrutiny. And that's a much, much harder test for the state to pass.
Exactly. And the government's argument, led by the Department of Justice, is a resounding yes, absolutely, these laws discriminate based on sex. Their core insight here, their main gotcha, if you will, is that the laws are a facial sex classification.
What do they mean by facial sex classification? Like
Yeah.
on the face of it?
Exactly. They mean the law's text itself, on its face, uses sex as the defining factor. You literally cannot describe what's banned without referencing sex. The government argues these laws impose two parallel rules on classes of people according to their sex.
Okay, that still sounds a bit abstract. How did the government illustrate that in court? Did they have an example?
They did, a really powerful example brought up in the oral argument. Imagine a minor plaintiff named Ryan Rowe, assigned female at birth, who wants to take testosterone as part of their transition. The law explicitly prohibits a doctor from prescribing that because his sex assigned at birth was female.
And here's where it gets really interesting and shows the government's point. If Ryan's sex assigned at birth had been male, that exact same medical treatment, testosterone, would not be restricted by this law. Same medication, same person seeking it, but whether it's legal depends solely on his sex assigned at birth. The government says that differential treatment based only on birth sex is sex discrimination, plain and simple.
Right. They even drew a direct comparison to Loving v. Virginia, the landmark Supreme Court case that struck down bans on interracial marriage. In Loving, the legality of a marriage depended entirely on the races of the individuals involved. Here, the government argues, access to medically necessary care depends solely on their sex assigned at birth. They contend that discrimination based on transgender status is inherently a form of sex discrimination.
All right, so that's the government's perspective. The law explicitly mentions sex assigned at birth, links the treatment to whether it's inconsistent with that sex, and that distinction creates unequal treatment based on sex. But how does Tennessee push back on that? What's their take?
Tennessee sees the law through a completely different lens. Their core insight is that the law doesn't care who you are or what your sex assigned at birth is. It cares what you're trying to do. They argue these laws regulate medical procedures based on their purpose, not the patient's sex.
The purpose being gender trans.
Exactly. They ban using these medications and surgeries specifically for the purpose of gender transition. But, they point out, the laws allow the same medications to be used for other valid medical reasons, like treating precocious puberty or hormone deficiencies. And they allow that regardless of the minor's sex assigned at birth.
Okay, so the state's analogy is that it's like banning the use of morphine to assist suicide while still allowing its use for pain management. The ban is on the purpose, not on the drug itself or the person needing pain relief. Is that it?
Precisely. And they argue the laws apply equally because neither boys nor girls assigned at birth can receive these treatments for the purpose of aligning with a gender different from their sex assigned at birth. Both are equally restricted in pursuing transition-related care.
And they look to pass Supreme Court cases like Godoldig, which dealt with pregnancy benefits, or Dobbs concerning abortion. In those cases, laws that clearly impacted one sex, women, were found not to be sex discrimination requiring heightened scrutiny because the law's text wasn't explicitly classifying based on sex on its face, but rather on a condition, pregnancy, or a procedure, abortion, that happens to affect one sex. Tennessee argues their laws are similar. They regulate a purpose, transition, not a sex.
Right, and this fundamental disagreement about whether the law classifies based on sex or purpose brings us right back to that crucial concept, heightened scrutiny.
Why does this legal term matter so much in this specific case? What's the big deal?
Because if the court finds the law does classify based on sex, triggering heightened scrutiny, the state's burden becomes much, much higher. They have to prove the law is substantially related to achieving an important government interest. Think of it as needing a really, really good reason, backed by strong evidence, to justify treating groups differently based on sex. If it's just rational basis review, the state only needs a rationally related reason, which is, frankly, a much easier hurdle to clear.
Okay, so the government argues heightened scrutiny applies for two main reasons. First, as we covered, the literal words of the law, inconsistent with sex, create that facial sex classification, which they say automatically triggers the higher standard.
And second, the government makes a powerful argument that transgender people should be recognized by the courts as what's called a quasi-suspect class.
A quasi-suspect class. What does that mean exactly, and why would that trigger heightened scrutiny?
It's a legal category courts use to identify groups who have historically faced discrimination and should therefore receive, well, heightened protection when laws impact them. Courts look at a few factors. One is whether the group has obvious, immutable, or distinguishing characteristics. The government argues the discordance between a person's sex assigned at birth and their gender identity fits this description, contending there's a strong biological basis for gender identity.
Okay, what else?
They also point to the history of discrimination transgender people have faced, from historical laws, like those banning cross-dressing, to the current rapid spread of legislation targeting trans individuals across states. And they argue that transgender people lack political power, being underrepresented and specifically targeted by laws like these bans, which is another factor courts consider for quasi-suspect status.
Makes sense, but the state pushes back on this too.
Oh, absolutely. The state and some justices pushed back hard on this quasi-suspect class idea. They questioned whether transgender status is truly immutable in the way race or biological sex are traditionally viewed by courts. They brought up concepts like gender fluidity, or instances where minors might desist from or detransition after initially identifying as transgender, suggesting it doesn't fit neatly into that immutable category.
And some justices also questioned if transgender people have the necessary history of de jure discrimination. That's discrimination written explicitly into the law itself, right? Like historical bans on interracial marriage or laws denying women the right to vote, which groups like racial minorities and women clearly have.
Exactly. That historical legal burden seemed to be a point of debate, which takes us to another absolutely massive piece of this puzzle, the medical and scientific evidence. Or perhaps more accurately, the battle over how to interpret and weigh that evidence.
Right, because the state's primary justification for these laws, their argument for why they pass any level of scrutiny, let alone heightened scrutiny, rests heavily on concerns about the medical treatments themselves, doesn't it?
Precisely. The government, representing the plaintiffs seeking access to care, presents a picture of overwhelming evidence. They argue that standard, appropriate gender-affirming care, including puberty blockers and hormones, guided by major American medical associations, is safe and substantially improves the mental health and well-being of transgender adolescents experiencing gender dysphoria.
What's gender dysphoria, just to be clear for everyone?
It's the clinical term for the significant distress or discomfort a person experiences because there's a mismatch between their sex assigned at birth and their gender identity. It's a recognized medical condition.
Got it. And the government says the treatments help alleviate that distress based on the consensus of major medical bodies.
Yes. They also address the state's concerns about things like using medications off-label, meaning using a drug approved for one condition to treat another. The government points out this is actually very common and considered safe in pediatric medicine generally, and they directly counter the specific risks the state highlights, like infertility, cardiovascular issues, impact on brain development, cancer, and sexual function.
How do they counter those? What's their evidence?
Well, they cite evidence presented in the lower courts suggesting these risks are either lower than the state claims, manageable, or simply not supported by robust studies. For instance, the district court judge who first heard the case found that many patients do remain fertile, and risks can often be mitigated. Experts testified that there's no strong evidence linking these treatments to specific cancers or negative impacts on brain development.
Okay. Now, flip to the state side, and you hear a very different narrative, right?
Oh, completely different. Tennessee, and you heard this echoed in questions from some justices, raise significant concerns about medical uncertainty, particularly for long-term effects. They often cite evolving approaches in Europe, mentioning reports like the Cass review in the UK, which has called for more caution and more research.
So while the U.S. government highlights medical consensus, the state highlights medical uncertainty and the need for caution. Is that the core difference?
That's a good way to put it. They emphasize potential serious risks, like this possibility of permanent infertility, which some opponents call sterilization, and the potential for regret or desistance, arguing these risks are substantial enough to justify the state stepping in with these bans to, in their view, protect minors.
And they question the quality of the evidence supporting this care for gender dysphoria specifically, asking about the lack of long-term randomized controlled trials.
Yes, that comes up a lot. Though the government counters that randomized trials are often difficult or even unethical to conduct in this area. And they argue that demanding this specific type of evidence for gender-affirming care when off-label use for many other pediatric conditions isn't questioned with the same suspicion is itself a form of unequal treatment.
This whole medical debate leads to a really fundamental question the justices seem to wrestle with. Is it even the court's job to weigh this kind of complex, evolving medical and scientific evidence? Some justices seemed hesitant, right? Suggesting this might be better left to state legislatures who can hold hearings, gather expert testimony, and adapt laws as the science evolves.
Exactly. But the government and the plaintiffs argue back that courts routinely assess scientific evidence in other areas. Think of toxic tort cases, or even when applying heightened scrutiny to laws based on biological differences like pregnancy. They insist that the core constitutional question is this discrimination must be addressed by the courts, even if it means diving into complex facts. It's the court's role, they say, to determine if the state's asserted interest, even if based on medical concerns, actually holds up and is substantially related to the law, especially under heightened scrutiny.
Okay, so beyond the big federal equal protection question, this case touches on another hugely important area: parental rights.
Yes, absolutely. The government argues that these state bans unconstitutionally interfere with the fundamental right of parents to make medical decisions for their children. This is particularly poignant when parents, in consultation with medical professionals they trust, determine that gender-affirming care is medically necessary for their child's well-being.
The documentary we looked at really drives this point home, doesn't it? Focusing on the families and the lawyers fighting these laws, highlighting how the bans override the difficult personal health care decisions parents are making for their children alongside their doctors.
It really does. And it's worth noting that this legal battle isn't confined to this single Supreme Court case. State courts across the country are grappling with these same issues, often under their own state constitutions and laws, which can sometimes offer different protections.
Yeah, we saw in the state court reports, for instance, that some state courts have found laws targeting trans people violate state equal protection guarantees, like in Utah and Iowa. In fact, an Iowa judge specifically ruled that gender identity is its own suspect class under the state constitution, separate from sex, which is pretty significant.
It is. Meanwhile, cases in Texas have shown conflicting rulings from different judges on whether parents have the right to make decisions about gender-affirming care for their children. It's very much in flux. And a Montana court suggested that state privacy and anti-discrimination laws might actually invalidate state laws that rely on rigid, binary definitions of sex. So a lot happening at the state level, too.
We also see, especially from groups arguing against transgender rights in these state cases, arguments sometimes raised about free speech or religious objections to providing services to transgender individuals. These echo debates we've seen at the Supreme Court level in other contexts, like cases involving religious objectors to providing services for same-sex weddings, for example.
Right. So stepping back, it's clear that this case, Scrutiny, and the broader legal landscape around it has enormous stakes. The documentary title itself, Heightened Scrutiny, really underscores how significant that legal standard is. The lawyers involved argue that this case has the potential to affect the constitutional rights of everyone in America, touching on fundamental principles of equality.
And the film also made a powerful point about the rapid legislative shifts we've seen. It highlighted that as recently as 2021, 0 states had laws banning gender-affirming care for adolescents. By 2024, that number had jumped to 23 states. The lawyer featured in the documentary drew a direct line from increasing media discourse questioning this healthcare, saying tens and tens of thousands of words have been written about it, to this rapid proliferation of state-level bans.
It's a striking correlation, they point out. So
Yeah.
beyond just access to care for transgender youth, what's really at stake here are these fundamental questions about how the Equal Protection Clause applies to sex and gender identity in a modern context. What is the proper power of states to regulate medical practice, especially when there are conflicting views, evolving science, and deeply personal decisions involved? And what is the appropriate role for judges and courts in reviewing laws based on complex medical facts and rapidly changing societal understanding? These are huge questions.
All right, let's try to recap this deep dive. We've seen how United States v. Scrutiny forces the courts to wrestle with whether state laws banning gender-affirming care for minors count as sex discrimination, a distinction that could trigger the demanding standard of heightened scrutiny.
We've navigated the sharply conflicting presentations of medical and scientific evidence, hearing arguments centered on established medical consensus and the benefits of care versus arguments focused on perceived uncertainty, potential risks like infertility and regret, and calls for more caution. And we've seen the complexities of applying constitutional standards to these deeply debated medical issues, along with the tensions around parental rights and the varied landscape in state courts.
Ultimately, the debate really boils down to a fundamental tension playing out in court. The state's asserted interest in protecting children and regulating medicine versus the individual rights of transgender minors and their parents to access medical care they believe is necessary, free from what their opponents argue is unconstitutional sex-based discrimination.
Right. And as the courts weigh these weighty arguments, trying to apply foundational constitutional principles to a world where both our understanding of gender and the science around related medical treatments are rapidly evolving, it leaves you to consider. How should equal protection be applied? How should we ensure both individual liberty and what the state sees as the common good, especially when profoundly personal medical decisions intersect with state power and deeply held, often conflicting, beliefs? It's a tough balance.